One of the suspects arrested in connection with the Case Street mass shooting faced a judge for the first time today. The April 3rd gang shootout left 6 dead and 12 hurt. Smiley Martin seen here in court. He was shot that day. He's now out of the hospital and in jail. Martin was officially charged with having a machine gun and being a felon with a gun during today's hearing. He did not enter a plea and is being held without bail.
Tonight, the Department of Corrections is refusing to provide answers about how Smiley Martin earned enough credits in prison to get out nearly 5 years early.
Yeah, that has some legal experts questioning how CDCR is interpreting public information laws. There you see Julie Watts, our investigative reporter. Julie, you've been working to get answers on this for quite some time.
Yeah, guys, the question is, should you have the right to know how a violent offender deemed too dangerous to parole earned enough credits to get out of jail anyway just months later? That's among the many questions we've been asking.
Less than a year before the deadly Sacramento mass shooting, suspect Smiley Martin was denied parole, found to pose an unreasonable risk of violence or criminal activity. The parole board noted outrageous assaultive behavior resulting in serious injuries to his female victim just 2 years after a prior conviction, and continued assaultive behavior while in prison. He was found guilty of battery on a prisoner and allegedly engaged in other criminal activity there. Yet months later, he was let out early anyway. CDCR says he earned enough credits to get out roughly 5 years early, but they denied our Public Records Act request asking how. The agency claims credit earning information is confidential, citing a series of government codes, except not a single one of these codes references credit earning. Is credit earning information exempted under any of these codes?
No.
Law professor Chris McKaylee says CDCR is broadly interpreting the legal codes, even though the Public Records Act says exemptions must be, quote, narrowly construed.
In CDCR's response, they merely cite specific code sections without explaining how credit earning information falls under any of those code sections.
We asked the agency to clarify, and in a statement they said credit earning information reflects an individual's record of incarceration, including their disciplinary history and rehabilitation. So what did Mr. Martin do to earn all those credits? Well, the parole board also found Martin's participation was, quote, limited as of May, completing just 1 month of dining room work, 4.5 months of a computer technology course, 11 months of a substance abuse program, and just 12 hours of a victims awareness program. Based on CDCR's credit earning website, this should have earned Martin just weeks of credit, not years.
This sort of highlights the unfortunate reality that's
Placer County DA Morgan Geyer is among many questioning how CDCR calculates early release credits and why they won't release the formula.
That remains a black hole of information. We don't know at what rate someone earns credits, how they lose their credits, and what they have to do to get them.
Now, since CDCR won't disclose Mr. Martin's credits, we asked generally how much credit do inmates lose after being found guilty of crimes in prison, and how much credit would someone earn for, say, a few months of dining room work and a couple computer classes. CDCR told us due to the individualized nature of credit earning, they couldn't answer our hypothetical questions either.